In this episode, we talk about a technology that could possibly enable scientists to create what are being called lab-grown babies. We also talk about how a municipality in Gujarat converted 6,000 kilos of plastic into over 3,000 square feet of garden tiles. But first, we talk about the laws against obscenity in the country. Hi, I'm Shashank Bhargava, and you're listening to Three Things, the Indian Express news show. Over the past few days, Ranveer Allahbadia, founder of the popular YouTube channel Beer Biceps, has found himself at the center of a massive controversy.
अब ऐसी खबर की बात करते हैं जो सोशल मीडिया पर काफी जिसकी चर्चा हो रही है। यूट्यूबर रणवीर अलाबादिया के खिलाफ शिकायत अब दर्ज की गई है।
एक पॉपुलर पॉडकास्टर ने एक शो में एक ऐसी बात बोल दी जिसके बाद पूरा सोशल मीडिया ही धुआं हो गया है।
माँ बाप जिन्हें ईश्वर का दर्जा दिया गया उनके बारे में ऐसी भद्दी, अश्लील, बेहुदी टिप्पणी की जाती है। करोड़ों लोग इस कंटेंट को देखते हैं। फिर सवाल ये,
Allahbadia has become the subject of a Mumbai police probe for the allegedly obscene comments he made during a guest appearance on the YouTube show India's Got Latent. In fact, the host of the show, comedian Samay Raina, is also under investigation right now. And it is not just the Mumbai police. Even the Assam police has filed an FIR against Allahbadia and Raina. The charges against them include those related to obscene acts under Section 296 of the Bharatiya Nyaya Sanhita. Now, the courts have heard plenty of cases related to obscenity in the past. But the question is, what actually counts as obscenity in India? To answer this question and to discuss how obscenity laws have changed over the years, the Indian Express's Ajoy Sinha Karpuram joins us. Ajoy, how does the law define obscenity and obscenity when it comes to online content as well?
So, obscenity has a slightly technical definition under Section 294 of the Bharatiya Nyaya Sanhita that belies how broad it is. It basically describes obscene material as anything that is lascivious or appeals to the prurient interest. Essentially, these are words that are meant to connote sexual content, overtly sexual content, and the definition of obscenity is largely aligned to that notion. It's not necessarily gore, it's not necessarily anything else. It's basically aimed at curbing content that is sexual for the sake of being sexual.
And in what ways can someone be penalized for violating such laws?
So there are a couple of different laws you can be punished under for this. As you mentioned, online obscenity is definitely something that's gaining a lot of traction these days. And for that, the Information Technology Act of 2000 actually has a punishment under Section 67, which is slightly more severe than the standard criminal law punishment. This is, you can be imprisoned for up to 3 years and fined up to rupees 5 lakhs for a first offense. In comparison to the BNS, where the maximum punishment for a first-time offense under this section is 2 years and the maximum fine is 5,000 rupees. So yeah, there is definitely a focus with the IT Act of maximizing the punishment for obscene content online.
And when we're talking about obscenity, and you mentioned how the law defines it, but isn't it all subjective? Like, how are they deciding what is overtly sexual or excessively sexual?
So this is actually funny because in a 1964 Supreme Court of the United States case, the judges on the bench were famously asked to describe what hardcore pornography was. And Justice Potter Stewart, after attempting, basically came down to, he said, "I shall not today attempt to further define the kinds of material I understand to be embraced, but I know it when I see it." So this sort of gets into the subjectivity behind all obscenity laws. Obscenity law, if almost inevitably at its basic form, comes down to what the judge believes is obscene. Even the Supreme Court in the Samaresh Bose case in 1985 acknowledged that though the court must consider the question objectively with an open mind, the question here being the question of what is obscene, the subjective attitude of the judge hearing the matter is likely to influence, even though unconsciously, his mind and his decision on the question.
So it depends on who's hearing the case.
In a lot of ways, it depends who's hearing the case. The Supreme Court has attempted to bring some objectivity to this question, but as can be seen in some more recent cases, especially concerning online content, it hasn't quite translated and there's still gaps to be filled, and there isn't a standard that all judges are following in this sense. One of the things they said in the Samaresh Bose case was, for eliminating any subjective elements, you can draw upon the evidence on the record or consider the views of other authors and what they believe is obscene and whether they believe that this work is obscene. This is a guideline. It doesn't necessarily help with the subjectivity because, once again, the judge could possibly choose which authors they like and which authors they don't like. But it's a constant effort.
And how far back can we trace this legal definition of obscenity?
So in the 1700s, there was an author named Edmund Curl. He supposedly was writing medical manuscripts of the sort. This was a thin veil over what was essentially erotica. And he specialized in writing about scandals, unauthorized biographies, and he was a dirt sheet writer. He was basically an early version of the paparazzi in a lot of ways. And he got in trouble in the 1720s for his translated work of a French piece of erotic literature called Venus in the Cloister or The Nun in Her Smock. And there were no obscenity laws at the time, but a lot of people wrote to the House of Lords complaining about this work. And eventually he was prosecuted for libel. And this is, if not the first, one of the first known cases of someone being prosecuted for an obscene publication. And in the century to follow, in around by 1857, England passed its first Obscene Publications Act. And it is basically this law that stems every definition of obscenity and every case of obscenity that we hear about today.
And often when we are talking about obscenity laws, the famous case against D.H. Lawrence's book, Lady Chatterley's Lover, often comes up, because that was another case that dealt with obscenity, that made headlines not just in England, but even in the United States and many other parts of the world as well, especially the Western world. But it even had an impact on India later on. Now, this book was first openly published in the UK around the 1960s. Can you talk about how that case shaped the obscenity laws here?
Yeah, so in 1964, the controversy of Lady Chatterley's Lover reached India after being dealt with in America and the UK. And the court was essentially asked to decide whether it was obscene or not. It's an aristocratic love story. It deals with a love affair. There are lots of depictions of sexual intimacy. And this, especially at the time that both Lady Chatterley's Lover was published and at the time where the question came up in the Supreme Court in India, was controversial. And the Supreme Court eventually held that it was in fact an obscene work. And to do so, they applied what they called the Hicklin test. This is from a case called Regina versus Hicklin in the United Kingdom, where it involves a man named Henry Scott who was selling these anti-Catholic pamphlets with a long title called The Confessional Unmasked, showing the depravity of the Romish priesthood, the iniquity of the confessional, and the questions put to females in confession. And this obviously rubbed certain people the wrong way, and the court was eventually asked to decide whether this was obscene content or not. Hicklin argued that he never intended for this to be obscene, and the court said his intention did not matter in this sense, and came up with a definition of obscenity that stood for over a century. And this was laid down by a judge by the name of Lord Justice Cockburn. He described obscene material as material which had a tendency to deprave and corrupt those whose minds are open to such immoral influences. Basically, he set the standard low. He basically said, if you are already seeking out obscene content, if you are the kind of person who's already open to this kind of content, then it is that person, that individual, their standard that will apply to everyone else. If they consider a certain kind of content to be obscene and appeal to their own obscene sensibilities, it is obscene for the rest of the world.
So the standard is being set by those who seek obscenity.
Absolutely, yes. And this is the standard that was borrowed and applied in India in the case of Ranjit D. Udeshi versus state of Maharashtra, where it was found that copies of Lady Chatterley's Lovers were being sold all over the state at bookshops. Yeah.
And Ajoy, how would you say the legal definition of obscenity has evolved over the years? How has it changed?
So ironically enough, at the time where in 1964, when this case was decided, the US and the UK had moved on from the Hicklin test. They had applied the Hicklin test for quite a long time, but they had since moved on from it. The UK through a new obscenity law whereby they basically defined obscenity by saying you have to look at the entire work. You can't just take a couple of passages here and there and say these are obscene passages, therefore the entire work is obscene. No, you have to see the context of where these passages come in and what they add to a narrative or the work in question. And in the United States, in the case of Roth versus the United States, they essentially moved on from the Hicklin test to what they called was the community standard test. Basically, moving the standard a little bit up and saying you have to look at the beliefs of an entire community and not just one quote-unquote immoral individual and see what they think of the work, and you have to consider the work as a whole. And this test was eventually adopted in India, though it took about 50 years between the Ranjit Udeshi case and in 2014 in the Avik Sarkar case. The Hicklin test was still being applied. There were obviously attempts to sort of make it more objective and make it more standardized, but it was a little wishy-washy until we got to Avik Sarkar and we decided to move away from that test entirely.
And the Supreme Court has obviously heard cases related to obscenity laws in the recent past. Can you talk about how the court has viewed these cases and have ruled in the matter?
So one interesting case that's actually quite recent from March 2024 is there was a YouTube series called College Romance, where basically depicting the lives of college students, how they go about, how they form friendships, the drama that is inevitably involved in stories like that. And there was an episode that had a lot of swear words, had a lot of vulgar and profane languages, a lot of verbal depictions of sex and people talking about sexual relationships. And some folks had an issue with that. Some folks said this was obscene content and filed a complaint against the creators. The creators tried to quash this case entirely, saying that this complaint has no basis, this is not obscene content, it should be thrown out at the outset. While the High Court did not allow this, on appeal, the Supreme Court agreed to quash the case. And Justices A.S. Bopanna and P.S. Narasimha basically drew a line distinguishing between something that is vulgar and something that is obscene. They said something can be, obscenity is specifically relates to material that arouses sexual and lustful thoughts, whereas not all abusive languages are used, or not all abusive language is used in that context. Abusive language is used in situations of high emotion, in situations where you're trying to get a point across, and in situations where you're just trying to hurt another person. And while you can have your own opinions about whether abusive language and profane should be used or not, it is clear that it's not always in the context of trying to arouse sexual feelings in another person. So here they again applied the community standards test, and they said that while the meaning of the words may be sexual in nature, their usage does not arouse sexual feelings, and the common usage of the words is reflective of emotions of anger, rage, frustration, grief, perhaps excitement. And this is especially notable now because we're dealing with another case of online content right now. We're dealing with Ranveer Allahbadia saying what he said on this talent show. And the question that the court is going to have to consider here is specifically with regards to the charges of obscenity, what was the purpose of these comments? Was the purpose of these comments to arouse sexual feelings or feelings of lust? Or was it to vent a certain emotion, vent anger, frustration, or in this case, humor, allegedly?
Okay, so if we are saying that something that is meant to deliberately arouse sexual feelings is obscene, can't someone make a case that a lot of romantic scenes in movies, for example, are violating these laws?
So going by a faithful application of the community standards test, you would have to see that maybe, yes, maybe arousing feelings of sex was a part of what was meant there, but it also forms a larger part of the narrative. That making you feel that is part of telling the larger story over here. And that this is probably this is a juncture in the story where the narrator wants you to feel that as opposed to the 20 other things you're going to feel in the rest of the movie.
And next we talk about something before which we should refresh what we learnt in our 9th standard biology class about reproduction. As most of you already know, for a baby to be produced, what you need is a male sperm cell to fertilize an egg from a female. Now, over the years, scientists have figured out how to recreate this process even in a petri dish. But for that to happen, you still require a sperm cell and an egg. But can you produce a baby without these two essential components? Is that possible? Well, turns out that it might be. By using stem cells collected from your skin, hair strands, or blood, scientists have been trying to produce what is essentially a lab-grown baby.
Yes, this process is called in vitro gametogenesis.
That's the Indian Express's Brendan Dabhi. And in case you missed it, the process is called in vitro gametogenesis, or IVG.
Essentially, what IVG implies is in vitro means in the lab, and gametogenesis, to develop gametes in the lab. So this is called IVG, where gametes, that is the sperm and eggs, are developed inside the lab using stem cells from the couple, and then developing an embryo from it, and then causing a pregnancy.
He says this method could potentially help older women, same-sex partners who wish to have biological children, and of course couples dealing with infertility.
While currently in vitro fertilization exists and a lot of people are helped by it, there are extreme cases where after the ages of 42, it becomes extremely difficult to procure good quality and good quantity eggs, right? And in some cases, even the sperm count is very low in the male. So in those cases, if IVG option is available, if and when it becomes available, it will enable couples to give their stem cells, which can then be developed into gametes in the lab. And then they can choose to have a baby, yes.
And Brendan, how realistic is this at the moment? At what stage of experimentation is this method at?
Right. So it is at its nascent stage at the moment, right? So researchers are still just being able to develop animals in the lab, right? So they are still dealing with mice at the moment. So the next step would be non-human primates, which is monkeys. So it is a long time away. In fact, doctors are quite consistent in saying that it is at least 10 years away, if not more. And that also depends on whether regulation will finally allow it to come to India. We don't know whether it will be allowed in other countries as well. So yes, it is 10 years away. And one of the interesting things is that it is so far away that it is not even being discussed in fertility association conferences today in 2025. However, with other countries like the United Kingdom already beginning deliberations on regulations, it is important to discuss this, its benefits, its pitfalls, and its conflicts in Indian law.
And you spoke to experts in the field, including many doctors in India. Can you talk about what are some of the things they told you, particularly about what this could potentially mean for Indians?
Yes, so doctors are very excited about this, okay? While they realize that it could have a lot of pitfalls, but they are very excited for it. Across the field, basically, people are excited that this could be a new frontier. This could basically revolutionize what we consider family, what we consider bloodlines, what we consider genetic families. So yes, it is very exciting, and you can have genetic babies when earlier it was not possible. It will make it possible for same-sex couples. It will be possible to be a solo parent. I'm sure, it depends on regulation, but IVG makes all of these things possible, where genetic parenthood can be achieved by non-heterosexual couples as well.
And Brendan, you were talking about IVF earlier, and that's a process where you're extracting an egg and sperm from a couple, fertilizing them outside the body, and then implanting the embryo in the woman's uterus. And that comes with its own complications. Can you talk about what is the current success rate for IVF?
Yes, so doctors say that currently 3.5 to 4 lakh IVF procedures are carried out in India per year. And the success rate of IVF is about 60%. However, we must take into account that as just now only heterosexual married couples are allowed to go for IVF, right? But as these couples age beyond 42, it becomes more and more difficult for them, even in the IVF procedure, to get a success rate. So one of the main exciting factors about IVG is that it will become viable for them to have a better success rate at having a child.
And the experts you spoke to also talked about the potential pitfalls. And there are a fair bit of ethical concerns here because you're essentially tailoring this process. Can you tell us about some of those concerns?
Yes, the concerns with regards to what one doctor described as made-to-order babies being ordered over a kiosk. So it is contentious, and the concept of designer babies and, the dark sense that eugenics brings. So the point here is that when you can develop gametes in vitro That means you can have any number of options to choose from, right? You can develop a number of embryos and you can choose which one to have a success rate. Now, what doctors are excited about is that we will be able to eliminate genetic conditions, genetic diseases, harmful conditions that exist in the parents that may not be passed on to the children. However, the fear of, evading natural selection and being able to select designer babies, that is very real. However, manipulating genetics, manipulating hair, manipulating nose, manipulating features is not possible at the embryonic stage at the moment. So, however, selection is possible. So, that is enough to cause concern among researchers and among bioethicists.
And you were talking about how this is at least 10 years away, if not more. But even when it does become available to the public, it won't be easily accessible, even just from the cost point of view, right?
Yes, so affordability is a major factor. When something like this comes, it is pointless to talk about it unless it's affordable, right? Because it's not only the rich who are infertile. There are couples across the spectrum who will require this technology and who will seek to use this technology. However, in vitro gametogenesis is not likely to become cheap immediately after coming into use. But however, doctors in the field do say that when you scale it up, and countries like India work on scale. So when you scale it up, it is likely to become cheap over the years, obviously, but not immediately.
And in the end, we talk about a municipality in Gujarat that has turned a massive amount of single-use plastic into a valuable civic amenity. This is the Halol municipality, and in total, they have recycled 6,000 kilos of plastic, converting it into over 3,000 square feet of garden tiles. This plastic was collected after a raid was conducted in the Gujarat Industrial Development Cooperation area, where the municipality seized 850 tons of thin plastic, which is banned under the local regulations.
So, as part of the Swachh Bharat mission for urban areas, the Halol municipality had proposed a waste to value project to the mission director of Swachh Bharat mission, under which the municipality proposes to reuse plastic and rubber waste generated in its area.
That's the Indian Express's Aditi Raja, who reports on Gujarat for the paper.
Now, Halol is a taluka in Panchmahal district, and Halol municipality is the governing civic body of the town. Halol is an industrial belt which is dominated by a lot of industrial units generating waste in plastic, and also the industrial dust, which is also known as fly ash, and other kind of wastes that pose a huge hazard to the environment and also bring up this question about how it should be disposed.
She says that waste to energy projects are now common in the country, but the Halol municipality came up with a waste to value idea,
in which the waste is taken, handed over to a startup that has been recommended by the Swachh Bharat mission, and it is converted into something usable.
And this is how they created over 3,000 square feet of garden tiles we mentioned earlier. To know more about this project, my colleague Ichha Sharma spoke to Aditi for this segment.
Aditi, can you tell us how did the municipality first get their hands, on this large amount of plastic, and then how did they go about processing it?
So the Halol municipality, led by its chief officer Hiral Thakur, had conducted a raid on January 21 in the Gujarat Industrial Development Corporation GIDC area near the town, accompanied by police teams of the revenue department, since GIDC is a notified revenue area and not directly under the control of the municipality, and also of course the police and the Gujarat Pollution Control Board. Now, this raid was basically carried out on the directions of the Gujarat Pollution Control Board, dated January 16, under Section 5 of the Environment Protection Act of 1986, for the enforcement of ban on single-use plastic. So, the Halol municipality, as part of this drive, raided plastic production units in Halol GIDC, under police protection, in which they seized 2 trucks of single-use plastic, and the total amount of plastic that was seized was 850 tons. So when the Halol municipality was faced with the question of the disposal of this 850 tons of single-use plastic, they did not want to just send it to a chemical furnace in, a cement factory, or they didn't want to return it back to the people from whom it had been seized, because then the whole purpose of the drive would be defeated.
Right, and we understand that according to the current provisions in place, you're supposed to destroy this kind of plastic. But like you said, they didn't want to do that. And they did eventually get the possession and ended up creating 3,000 square feet of garden tiles with it. So can you tell us, how did they go about doing this?
So out of the 850 tons of single-use plastic, 6,000 kilos were sent to a startup based in Gandhinagar called Saltec. So the startup is among those recommended under the Swachh Bharat mission to civic bodies for the use of technology that they have patented in 7 countries. And it has also fitted about 17,000 square feet of similar tiles that Halol municipality has got them to make out of this plastic at the Pandit Deen Dayal Energy University in Gandhinagar, which is the alma mater of startup founder Aditya Shukla. Now, by implementing the technology, Thakur also feels that they are giving, an opportunity to startups to come forth and help in projects related to environment. Now, according to Thakur, the technology that has been used in this is a blending industrial dust with plastic. Now, industrial dust in itself is a waste generated by industries that causes a big issue with disposal. So by this project, not only has the plastic been taken care of, but also the industrial dust which is generated in Halol and other parts where there are industries, they can also be put to use.
And also, Aditi, could you talk a little bit about the actual process that this startup used to convert the single-use plastic into the garden tiles?
So the Halol municipality gave the startup 6,343 kilos of single-use plastic to be precise, which was mixed with 5,190 kilos of ash filler or industrial dust in the ratio of 55 to 45 to create the tiles that now cover a space of 3,295 square feet. And they have been installed in the civic garden in Halol town, which is the garden of the municipality. According to Thakur, not only are these tiles sturdy, but they are also cost effective as they turn out to be cheaper by 18 rupees as compared to cement blocks of the same size and bringing the carbon footprint to 0. So the total carbon footprint reduction that happened in this particular pilot project was 17,414 kilos, which is a significant number. Now, what the municipality has also estimated is that if they use the entire 850 tons of confiscated single-use plastic and converted only into tiles, it would cover a space of 4,21,000 square feet and cut down on the carbon dioxide emission by 2,172 tons, which is a lot, And so Thakur is very positive about, setting up this pilot project as a model for other civic bodies also to emulate and, decide how they could eliminate and dispose of the plastic waste that they actually raid or, get in their everyday garbage collection.
Another thing, you write that it's not only tiles, but the municipality is also planning to make something like benches and monoliths. So do they have an estimate for how valuable this kind of plastic is?
So Thakur has also told us that, the confiscated material, which is illegal single-use plastic, is worth a total of 15.5 crores if it is sold to vendors, because vendors have to purchase this illegal plastic also from the producer at a cost of about rupees 180 per kilo. So currently, with this pilot project in place, there is a lot of hope that the Urban Development Department will probably be able to proceed with this kind of recycling and reuse of plastic to reduce the impact on environment and also carbon footprint.
You were listening to 3 Things by the Indian Express. Today's show was written and produced by me, Shashank Bhargava, and was edited and mixed by Suresh Pawar. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it, share it with a friend or someone in your family. It's the best way for people to get to know about us. You can tweet us at Express Podcasts and write to us at podcasts@indianexpress.com.